The right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013. Chapter 4. Notification and acquisition. Section 11. Publication of preliminary notification and power of officers. 1. Whenever it appears to the appropriate government that land in any area is required or likely to be required for any public purpose, a notification, hereinafter referred to as preliminary notification to that effect along with details of the land to be acquired in rural and urban areas shall be published in the following manner, namely: A. In the official gazette. B. In 2 daily newspapers circulating in the locality of such area, of which one shall be in the regional language. C. In the local language in the panchayat, municipality or municipal corporation, as the case may be, and in the offices of the district collector, the sub-divisional magistrate and the tehsil. D. Uploaded on the website of the appropriate government. E. In the affected areas, in such manner as may be prescribed. 2. Immediately after issuance of the notification under subsection 1, the concerned Gram Sabha or Sabhas at the village level, municipalities in case of municipal areas, and the autonomous councils in case of the areas referred to in the 6th schedule to the Constitution, shall be informed of the contents of the notification issued under the said subsection in all cases of land acquisition at a meeting called especially for this purpose. 3. The notification issued under subsection 1 shall also contain a statement on the nature of the public purpose involved, reasons necessitating the displacement of affected persons, summary of the social impact assessment report, and particulars of the administrator appointed for the purposes of rehabilitation and resettlement under section 43. 4. No person shall make any transaction or cause any transaction of land specified in the preliminary notification or create any encumbrances on such land from the date of publication of such notification till such time as the proceedings under this chapter are completed, provided that the collector may, on the application made by the owner of the land so notified, exempt in special circumstances to be recorded in writing such owner from the operation of this subsection. Provided further that any loss or injury suffered by any person due to his willful violation of this provision shall not be made up by the collector. 5. After issuance of notice under subsection 1, the collector shall, before the issue of a declaration under section 19, undertake and complete the exercise of updating of land records as prescribed within a period of 2 months. Section 12. Preliminary survey of land and power of officers to carry out survey, for the purposes of enabling the appropriate government to determine the extent of land to be acquired. It shall be lawful for any officer, either generally or specially authorized by such government in this behalf, and for his servants and workmen, A. To enter upon and survey and take levels of any land in such locality. B. To dig or bore into the subsoil. C. To do all other acts necessary to ascertain whether the land is adapted for such purpose. D. To set out the boundaries of the land proposed to be taken in the intended line of the work, if any proposed to be made thereon, and E. To mark such levels, boundaries in line by placing marks and cutting trenches, and where otherwise the survey cannot be completed and the levels taken and the boundaries in line marked, to cut down and clear away any part of any standing crop, fence or jungle. Provided that no act under clauses A to A in respect of land shall be conducted in the absence of the owner of the land or in the absence of any person authorized in writing by the owner. Provided further that the acts specified under the first proviso may be undertaken in the absence of the owner, if the owner has been afforded a reasonable opportunity to be present during the survey, by giving a notice of at least 60 days prior to such survey. Provided also that no person shall enter into any building or upon any enclosed court or garden attached to a dwelling house unless with the consent of the occupier thereof without previously giving such occupier at least 7 days' notice in writing of his intention to do so. Section 13. Payment for damage. The officer so authorized under Section 12 shall at the time of entry under Section 12 pay or tender payment for any damage caused, and in case of dispute as to the sufficiency of the amount so paid or tendered, he shall at once refer the dispute to the decision of the collector or other chief revenue officer of the district, and such decision shall be final. Section 14. Lapse of Social Impact Assessment Report, where a preliminary notification under Section 11 is not issued within 12 months from the date of appraisal of the Social Impact Assessment Report submitted by the expert group under Section 7, then such report shall be deemed to have lapsed and a fresh social impact assessment shall be required to be undertaken prior to acquisition proceedings under Section 11. Provided that the appropriate government shall have the power to extend the period of 12 months, if in its opinion circumstances exist justifying the same. Provided further that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded on the website of the authority concerned. Section 15. Hearing of objections. 1. Any person interested in any land which has been notified under subsection 1 of Section 11, as being required or likely to be required for a public purpose, may within 60 days from the date of the publication of the preliminary notification, object to a. The area and suitability of land proposed to be acquired. b. Justification offered for public purpose. c. The findings of the Social Impact Assessment Report. 2. Every objection under subsection 1 shall be made to the collector in writing, and the collector shall give the objector an opportunity of being heard in person or by any person authorized by him in this behalf or by an advocate, and shall, after hearing all such objections and after making such further inquiry, if any, as he thinks necessary, either make a report in respect of the land which has been notified under subsection 1 of Section 11, or make different reports in respect of different parcels of such land to the appropriate government, containing his recommendations on the objections, together with the record of the proceedings held by him along with a separate report giving therein the approximate cost of land acquisition, particulars as to the number of affected families likely to be resettled, for the decision of that government. 3. The decision of the appropriate government on the objections made under subsection 2 shall be final. Section 16. Preparation of Rehabilitation and Resettlement Scheme by the Administrator. 1. Upon the publication of the preliminary notification under subsection 1 of Section 11 by the Collector, the Administrator for Rehabilitation and Resettlement shall conduct a survey and undertake a census of the affected families, in such manner and within such time as may be prescribed, which shall include a. Particulars of lands and immovable properties being acquired of each affected family. b. Livelihoods lost in respect of land losers and landless whose livelihoods are primarily dependent on the lands being acquired. c. A list of public utilities and government buildings which are affected or likely to be affected, where resettlement of affected families is involved. d. Details of the amenities and infrastructural facilities which are affected or likely to be affected, where resettlement of affected families is involved, and a. Details of any common property resources being acquired. 2. The Administrator shall, based on the survey and census under subsection 1, prepare a draft rehabilitation and resettlement scheme, as prescribed, which shall include particulars of the rehabilitation and resettlement entitlements of each landowner and landless whose livelihoods are primarily dependent on the lands being acquired and where resettlement of affected families is involved. 1. A list of government buildings to be provided in the resettlement area. e. Details of the public amenities and infrastructural facilities which are to be provided in the resettlement area. 3. The draft rehabilitation and resettlement scheme referred to in subsection 2 shall include time limit for implementing rehabilitation and resettlement scheme. 4. The draft rehabilitation and resettlement scheme referred to in subsection 2 shall be made known locally by wide publicity in the affected area and discussed in the concerned Gram Sabhas or municipalities. 5. A public hearing shall be conducted in such manner as may be prescribed, after giving adequate publicity about the date, time and venue for the public hearing at the affected area. Provided that in case where an affected area involves more than one Gram Panchayat or municipality, public hearings shall be conducted in every Gram Sabha and municipality where more than 25% of land belonging to that Gram Sabha or municipality is being acquired. Provided further that the consultation with the Gram Sabha in scheduled areas shall be in accordance with the provisions of the Panchayat's extension to the Scheduled Areas Act. 1996. 6. The administrator shall, on completion of public hearing, submit the draft scheme for rehabilitation and resettlement along with a specific report on the claims and objections raised in the public hearing to the collector. Section 17. Review of the rehabilitation and resettlement scheme. 1. The collector shall review the draft scheme submitted under subsection 6 of section 16 by the administrator with the Rehabilitation and Resettlement Committee at the project level constituted under section 45. 2. The collector shall submit the draft rehabilitation and resettlement scheme with his suggestions to the Commissioner Rehabilitation and Resettlement for approval of the scheme. Section 18. Approved rehabilitation and resettlement scheme to be made public. The Commissioner shall cause the approved rehabilitation and resettlement scheme to be made available in the local language to the Panchayat, municipality or municipal corporation, as the case may be, and the officers of the district collector, the sub-divisional magistrate and the tehsil, and shall be published in the affected areas, in such manner as may be prescribed, and uploaded on the website of the appropriate government. Section 19. Publication of Declaration and Summary of Rehabilitation and Resettlement. 1. When the appropriate government is satisfied, after considering the report, if any, made under subsection 2 of section 15, that any particular land is needed for a public purpose, a declaration shall be made to that effect, along with a declaration of an area identified as the resettlement area, for the purposes of rehabilitation and resettlement of the affected families, under the hand and seal of a secretary to such government or of any other officer duly authorized to certify its orders, and different declarations may be made from time to time in respect of different parcels of any land covered by the same preliminary notification, irrespective of whether one report or different reports has or have been made wherever required. 2. The collector shall publish a summary of the rehabilitation and resettlement scheme along with declaration referred to in subsection 1. Provided that no declaration under this subsection shall be made unless the summary of the rehabilitation and resettlement scheme is published along with such declaration. Provided further that no declaration under this subsection shall be made unless the requiring body deposits an amount, in full or part, as may be prescribed by the appropriate government toward the cost of acquisition of the land. Provided also that the requiring body shall deposit the amount promptly so as to enable the appropriate government to publish the declaration within a period of 12 months from the date of the publication of preliminary notification under section 11. 3. In projects where land is acquired in stages, the application for acquisition itself can specify different stages for the rehabilitation and resettlement, and all declarations shall be made according to the stages so specified. 4. Every declaration referred to in subsection 1 shall be published in the following manner, namely: A. In the official gazette. B. In 2 daily newspapers being circulated in the locality, of such area of which one shall be in the regional language. C. In the local language in the panchayat, municipality or municipal corporation, as the case may be, and in the offices of the district collector, the sub-divisional magistrate and the tehsil. D. Uploaded on the website of the appropriate government. E. In the affected areas, in such manner as may be prescribed. 5. Every declaration referred to in subsection 1 shall indicate: A. The district or other territorial division in which the land is situated. B. The purpose for which it is needed, its approximate area, and C. Where a plan shall have been made for the land, the place at which such plan may be inspected without any cost. 6. The declaration referred to in subsection 1 shall be conclusive evidence that the land is required for a public purpose, and, after making such declaration, the appropriate government may acquire the land in such manner as specified under this Act. 7. Where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded, provided that in computing the period referred to in this subsection, any period or periods during which the proceedings for the acquisition of the land were held up on account of any stay or injunction by the order of any court shall be excluded. Provided further that the appropriate government shall have the power to extend the period of 12 months, if in its opinion circumstances exist justifying the same. Provided also that any such decision to extend the period shall be recorded in writing and the same shall be notified and be uploaded on the website of the authority concerned. Section 20. Land to be marked out, measured and planned including marking of specific areas. The collector shall thereupon cause the land, unless it has been already marked out under Section 12, to be marked out and measured, and if no plan has been made thereof, a plan to be made of the same.